I'm gonna start over for the recording. There we go. All right, so my guest tonight is Liz Wallace. She's an estate planning, elder law, and asset protection attorney, and she works both here in the Tri-Cities and throughout Washington, and a little bit of Idaho, I remember you saying, yeah. And her emphasis tonight is not only on estate planning, but how it relates to paying for long-term care. And since we are all ladies on this call, it's, to me, just an extra important part of our planning as women, both because we tend to be the recipients of long-term care. We need it more than than men, and or we end up being caregivers a lot of times for husbands or others in our family who are experiencing long-term care events. So we are deeply impacted, both mentally, emotionally, and definitely financially. So it's a very important topic. I'm excited that she's able to come talk with us tonight. And Liz, is there anything else you would like to add to introduce yourself?
I don't think so. Thank you.
Agile Elder Law. I don't think I said your business name. Agile Elder Law. So thank you for joining us. All right, go right ahead.
Okay, thank you, Angie. I want to start by saying this is not my favorite format. I certainly am happy to be able to do this webinar. I have put some stuff on PowerPoints. Normally, I like to actually be able to use a whiteboard and explain stuff as I go along, because it's a little easier to explain some of these more in-depth estate planning concepts that way. However, we don't have that as an option, so I've done my best to kind of create a PowerPoint, and I'm going to share my screen and show you guys that. But please do not hesitate to ask any questions about this stuff. It is complex, it's complicated, and it's a little hard to show you through a screen. So I want to preface by saying, please ask questions, and please don't feel, if you feel overwhelmed or feel like this is a lot of stuff, it's not because you're not smart enough to get it, it's because it's really complex. So I'll do my best to break it all down. And I'm going to switch now and share my screen if I can. Let's see here. All right, can everyone see that? Yep, okay. All right, so we're going to talk about estate planning and long-term care. I'm going to start out by talking about estate planning and what the heck that even means, and then talk about kind of some of the documents that are involved in estate planning, and then I'm going to apply that and kind of show you why that matters as far as long-term care and a few other things that can be a threat to people's livelihood and their money and their estates. So we're going to start with estate planning itself. So first of all, what is estate planning? And Angie kind of talked about this a little bit. Estate planning is not just for after death. So it's planning for now, during your lifetime, and later. And so while you're talking about planning for your lifetime, you're talking about who's going to help you make decisions for things, how do you protect assets for yourself now, how do you make sure that you can pay the costs of living as you go throughout your life for yourself and your spouse and your kids. It also means after death, and that is more of where you want your property to go. And when it gets there, do you want to provide protections for your surviving spouse, for your children, or other loved ones who might be getting assets from your estate? This helps you be able to live the life you want to live now and make sure that your assets end up where you decide you want them to go, along with any protections that you might want included in that transfer of assets. So what are the main documents that are involved in a estate plan? The first of these is your powers of attorney. These are the documents that you sign that say, I'm going to give this person whom I trust the ability to help me and to make decisions for me if I can't make them for myself. It's important to know that these are only valid while you're alive. So if you die, your power of attorney is no longer valid and it no longer carries weight. So these are documents that allow you to pick the person who's going to help you with things while you're alive. It gives them the authority to help you with things while you're alive. And this might be healthcare or finances, and I'm going to go a little more into detail here in a minute. But powers of attorney are for while you're alive. Your healthcare directive is also a document that comes into play while you're alive. This is the document that tells everybody at the end of your life, if you can't tell them yourself, what you want. So this tells them at the end of your life, if you cannot speak for yourself and you can't make your own healthcare decisions, do you want heroic measures taken to keep you alive at the end of your life? Or do you want them to let you go? A will and a trust are documents that determine what happens with your property when you die. So even though you can have what's called a living trust, and so that also kind of controls your property while you're alive, the point of these documents is more to determine what happens when you pass away. So these are documents that you put into place that say, this is all the property I have, and this is what I want to have happen with my property when I pass away. Right. And then beneficiary designations. Beneficiary designations are for things like bank accounts, IRAs, other investments, life insurance, things that pass directly to a person upon your death and that pass outside of your will or your trust. They have beneficiary designations. So you choose when you invest in something or when you open a bank account, when I die, please give anything that's left in this account to this person, and if they're not around, then to this next person. That's what's called a beneficiary designation. And it goes outside your will or trust, and also it can override, in most cases, whatever your will or your trust says. So it's important that if you have your estate planning done by anybody, any attorney, they need to make sure that they also help you set up your beneficiary designations to match what's in your estate plan, because I could draft the best, most perfect will for you that has all these protections and make sure your property goes exactly where you want it to go. But if I didn't tell you how to set up your beneficiary designation to match that, then whatever your beneficiary designation says is what goes, and we're out of luck as far as all of the work that we did to set up the will. So if you ever go to get your estate planning done by an attorney and they don't talk to you about your beneficiary designations, go somewhere else, because it's a huge part of our property, especially in the US, that passes through beneficiary designations and not through your will or your trust. Okay, so I want to talk to each of them a little bit in depth. I want to start with powers of attorney. I mentioned that, I think I didn't quite mention, I was going to, that you should have 2 powers of attorney. One of those should be for finances and one should be for healthcare. And I know that some of you on this call work or know people who work in healthcare, and you probably know firsthand that hospitals and healthcare other billing departments would like as much as possible to ignore a power of attorney, just like banks would like to ignore a power of attorney, because the longer you leave your money in the bank or the longer you're kept alive in a hospital, the more those 2 institutions make off of your assets or your life. And so we want to have separate ones, one for finances and one for healthcare. That way, the bank can't say your power of attorney looks like it's a power of attorney for healthcare, so we don't have to honor it. And the hospital can't say your power of attorney looks like it's one for finances, so we don't have to honor it for your healthcare decisions. So just to make that simple and take away something for anyone to fight about, we make one for finances and one for healthcare. Also, what oftentimes happens is people might have more than one child, and they have one child who they know no matter what happens, that child will make sure that every bill of theirs gets paid on time, never miss anything, make sure, they talk all the time to investment folks, make sure that everything financial is taken care of. But that same kid could never make the tough decisions in the hospital for you if they needed to. But on the other hand, you might have a kid who can make those tough healthcare decisions, but maybe is not going to be quite as on top of the financial stuff as you'd like. So you have one kid who's in charge of your healthcare and one kid who's in charge of your finances. That's another reason for having separate powers of attorney. So you use this document to nominate someone while you're alive, and this is the person who's going to help you with these things. It's important to note that this does not take away your rights. I oftentimes will have people come to me and say, well, I have power of attorney for my mom or for my brother or for my kid, and they're going and doing and making these decisions that I know are not the best for them. So how do I use the power of attorney to stop them from doing that? And the answer is you can't. These documents do not exist to take away your rights, and they do not exist to substitute someone else's decision-making power for your own. You get to make your own decisions, even if they're bad ones. Even if you want to take all your money and go to the casino and gamble, you get to do that. And whoever's on your power of attorney cannot stop you from doing that. But they can help you do the things that need to be done. They can be the one to go down to the bank and pull the cash out for you. Or they can be the one to go and pay your bills if you can't do that because you had surgery and you're in the hospital. Or maybe you need them to go down and pick up a prescription from the pharmacy and you can't do that yourself. So on your healthcare power of attorney, you're sending this person down there to do that. They've been given all of this power to help you with things, but they do not get to take away your rights or make decisions for you. Now, if you can't speak for yourself, if you're in a coma or you have dementia or for whatever reason you can't let everyone know what decisions you would make, then the person who's on your power of attorney can make decisions for you, but they must either do what they know that you would want or do whatever is in your best interest if they don't know what you would want. So what I like to do for my clients, and this is optional and this is not necessarily a part of estate planning per se, but what I do is when I do powers of attorney for my clients, I also have them fill out kind of a longer sheet that I call a values sheet. And it's just lists a whole bunch of scenarios and kind of discussion questions for what my clients would want in certain situations if they can't speak for themselves. That way, by keeping that values worksheet along with their powers of attorney, the person who's on their power of attorney has some idea of what they would want in those situations. So I combine those two things. The power of attorney is the one that gives the person the power to make those decisions and to do those things for you. But then you also have this worksheet that says, if these situations happen, this is how you know what I want, because I wrote it down here. And I always encourage that, though it's not necessarily a required part of estate planning. Your power of attorney should be thorough and it should be immediately effective. Does the idea of it being immediately effective kind of scare you guys a little bit? Yes? Yes, I see a lot of heavy nods. Okay. So let me explain kind of why I say that's important. You might have a situation where maybe you get into a car accident and you break your leg, okay? And you're in the hospital and you have a broken leg and you can't leave the hospital and you can't go out and take care of paying your bills or go take go get cash from the hospital so that you can put it in a card and mail it off to your nephew whose birthday it's going to be. You can't go down to the pharmacy yourself and pick up your prescription. If you have a power of attorney that says it's not effective unless I am disabled, I am unable to manage my own affairs, and they need a doctor's note in order to do that, the problem you run into is you've broken your leg and you're stuck in the hospital or at home, wherever you're stuck in bed. And your person who's on your power of attorney goes to your doctor and says, I need a note that says that Liz can't manage her own affairs. Do you think any doctor is going to give a note to someone that says, I can't manage my own affairs because I have a broken leg? Definitely not. And we don't want them to, because that's not a true scenario. So if my power of attorney is effective only upon my incapacity or disability, now I need these people who I've nominated to help me with things to go and do those things for me, but they can't. And they can't get the doctor's note that they need to. And if they try to go to the bank with a power of attorney that says they need a doctor's note and they don't have the doctor's note, they're not going to be able to do those things. So this is why I say having them effective immediately is more helpful. Because remember, you're not taking away any of your own rights. You're still making all of those decisions yourself. And you're still picking the people you want to do it. And you can revoke this document anytime you want. So if you have it immediately effective, that means that people really can help you when you need the help instead of needing to wait around and get a doctor's note or take the time. I mean, sometimes there's no time, right? What if you got in a car accident and you needed some emergency surgery and they needed someone to be able to sign for that? Well, you don't want to wait around for a doctor's note in that case, maybe. So this is why I say they should be immediately effective. And they should be thorough. The way that our statute works here in Washington for powers of attorney says that if you have a power of attorney, you automatically get to do a certain list of things. And that list is lengthy, but it's not everything. It also says if you want the person on your power of attorney to be able to do all these other things, and then there's a whole nother list of things, then it has to specifically say they can in their power of attorney. So what this means is, let's say that we were doing some planning for someone who was going to need Medicaid. So here's a long-term care planning example. Say I had a couple come to me, and one of them needed care and one of them did not. So say it's a husband and wife, and the husband needs care and the wife does not. And they need Medicaid, okay? There's a Medicaid rule that says within the first year, in order to stay qualified for Medicaid, let's say they don't have any other qualification issues. Say they only have a house and they don't have any other assets. So she's going to qualify for Medicaid, or he's going to qualify for Medicaid. Well, in that year, you have to transfer the house into the name of the spouse who doesn't need Medicaid in order to stay qualified. The power of attorney statute says that in order to give gifts of things to people, especially if you're giving them to yourself, then it has to be specifically spelled out in your power of attorney. Well, if their power of attorney doesn't spell that out, then we can't transfer the house to the spouse who doesn't need Medicaid, and we run into a lot of problems. One being that they have to stay qualified for Medicaid. The other being that when the state comes in later and gets a lien on the assets of the person who got Medicaid, they're going to be able to put a lien on half of that house. Now, if we're able to transfer it to the person who doesn't need Medicaid, the spouse who doesn't, then we can avoid the lien, and the spouse who presumably is going to be a surviving spouse, the one who doesn't need Medicaid, doesn't have to worry about this lien from the state on their house. None of that is as simple as that solution is by putting the house in the name of the spouse who doesn't need Medicaid. If that person who needs Medicaid has dementia or can't sign themselves, the power of attorney is where we get the authority to do that transfer. And without it being specifically spelled out there, we can't preserve assets for that person. I know that's kind of a long-winded explanation. And did I lose everybody, or did you guys kind of understand? Still with me a little bit? Okay. Those of you who are nodding anyway. So your power of attorney should be really thorough, because I want it to have all of the powers I need later to help you preserve assets through this power of attorney. And if that's not listed specifically, I can't preserve assets, and we're kind of out of luck. So the more thorough, the better. My powers of attorney are not as lengthy as all elder law attorneys are, but they're about between 8 and 10 pages, depending on what people need. And the reason for that is that they are all situations that I've seen later on where I needed a certain power to do something through a power of attorney. And so I've added it over time into my powers of attorney. Any questions about that? Why I say it should be thorough and why I say it should be effective immediately? No? Okay.
I'm sorry. I think, Liz, my question is, how do you know what you need when you're starting the process?
So one of the ways that you know what you need is you work with someone like me who's seen a whole lot of things. That's partially it. The difference between elder law attorneys like me and normal estate planning attorneys is that I also do the other side of this work. So I work with people who now need care and now are in crisis and need to figure out how to preserve assets. And so I take all of my experience doing that on the back end and put it into my estate planning stuff on the front end. And that way we have a good idea of all these scenarios that we need to plan for. Also, elder law attorneys, we're really good at working together. So one of the nice things about my area of law is that we're not really cutthroat. We all kind of are serving the same people and really trying to do the best job we all can together. And so we, at our CLEs and our group activities, we exchange a ton of information. So people, we talk about what did we run into, what did we prepare for, what's the best way to do this in this scenario, or these things came up, and what would you do here? And so it really helps inform all of us. It's one of the great things about this area of law is the kind of camaraderie that we have as elder law attorneys. So, if you come to someone like me who's a member of our groups and stuff, you kind of get the benefit of the experience of all of those folks at once. Does that answer your question?
It does. For me, I think I'm more just on the starting end. Me and my husband are just in our early 50s, but it's something that I would rather take care of now than, as you say, in a crisis situation, yes. And then you focus on it.
Mm-hmm. And I am going to talk a little bit about, when should you start planning? But the answer is now. I mean, the answer is really yesterday, but now is the time. And I'll just say, it's important to know that just because you are starting your estate planning earlier than you're going to need care and before you're retired, that does not mean that you can't develop an estate plan that will cover you both now and then without changing it.
Okay.
So a good estate plan really can stand the test of time. You shouldn't have to redo your estate plan repeatedly because your life changes a lot. So that's another thing to consider.
Okay, thank you.
Welcome. Okay, any questions about powers of attorney? I'm going to move on a little bit to other stuff. Good? Okay. Go ahead.
Can I ask a question?
Yes.
Are these documents then filed someplace other than in the grantees or in my name, in my safe, or are they with the attorney, or are there other areas that they need to be recorded?
So I don't like to record powers of attorney, and it's not required in Washington to do so. I'll say that first and foremost. You are not required to file them anywhere. I give my originals back to my clients. I always make sure I have a scanned copy of everything that's been signed, so that if you ever needed it sent somewhere, emailed somewhere, you can just give me a call and I can send it off. So I always have an electronic copy of everything, but I give the originals back to the clients because sometimes you need the original document to effectuate changes. So you can file these documents with the county in which you live. And the county clerk will put them into their vault and hold on to them. And then if you ever needed to go and get it, you could, if it's a will. Otherwise, the county auditor would hold a copy of your powers of attorney. And you can do that, but that means that if you ever needed to change it, you need to make sure that you don't forget that you recorded it somewhere, so that someone doesn't go and get the recorded copy and say, aha, I have this one that she recorded with the county. This must be the real document. And someone else says, no, wait, she changed it later. You're kind of asking for arguments back and forth, and there's no need to do so. The only time that the law ever requires that you file a power of attorney with the county is if you are transferring a piece of property, real property, so a house or a piece of land, and then it gets recorded with the deed itself. It doesn't get recorded as a separate document.
Thank you.
You're welcome. Any other questions on powers of attorney? No? Okay. And is this light distracting? I was going to try and change my blinds. It's just the sun is coming down. No? Okay.
I have a question. In instances where the older adult has a child as the POA and they're seeking to transfer their real estate property to the offspring in order to remain Medicaid eligible, how does that work as far as timeline of when you have to make that transfer so that it doesn't create a, I'm losing my words, it's late in the day. It doesn't ding you. Like I said, losing words.
So the answer to your question is 5 years. The better answer is don't do that. So, I mean, I'm sure you already know that, that there are definitely consequences for any kind of gifting. And I wouldn't say you never gift stuff when planning for Medicaid, because certainly sometimes we use that very much as part of our strategies. But if you're thinking about giving something to your kids, there are lots of tax reasons, for example, not to gift real estate to a child during your lifetime, because they will lose some tax benefits that they might get otherwise if they inherited it. There are also some complex Medicaid rules that might mean that even if you gave it to them, you still could get dinged for it later, or the state could decide that you hadn't fully gifted it to them. For example, if you give a house to a trust and you continue to live in the house, then the state's going to say, well, you didn't really actually give that property away because you still lived there. So there are a lot of complexities when it comes to that kind of planning. It doesn't mean you can't do it. But it does mean, I always say, at least have a conversation with an elder law attorney first, because you really can run into issues that you had no idea were there when you're trying to do the right thing, but this stuff is really complex. So 5 years, though, is the short answer to your question.
Thank you.
Any other questions about powers of attorney stuff? No? Okay. So I'm going to move on to healthcare directives. As I mentioned, this is the document that tells people at the end of your life whether or not you want heroic measures taken to prolong your life, or you want them to let you go. Now, this document only takes effect if you're at the end of your life and 2 doctors have confirmed that your life cannot be saved. And most importantly, you cannot speak for yourself. Anytime you can speak for yourself, you get to make your healthcare decisions, especially this one. No one else can make this decision for you unless you have given them the ability to do so under a power of attorney, and then also cannot speak for yourself. Okay. This document can be as thorough as you want, with as many conditions as you want. And this is something I don't think people realize. Oftentimes, healthcare directives will say, I do or do not want artificial nutrition and hydration at the end of my life. And that's the minimum amount of things you have to answer as far as the state is concerned. So the statute says at least you have to say these things. But there's no maximum to the things that you can say about what you want to have happen at the end of your life. So you can talk about everything under the sun. It doesn't just have to be nutrition and hydration. You can say, I want pain medication. I don't want pain medication. I don't want blood transfusions. I don't want kidney dialysis. I don't want antibiotics. These can be as thorough as you want. And please do be, because this is the document that you're using to tell people, this is what I want. And speaking as, when my dad died, he was in the hospital for about 36 hours, and my brother and I had to make this decision. He died suddenly, and he didn't have a healthcare directive. And so we had to make these decisions for him without really knowing exactly what his wishes were. And I can tell you, it sure would have been nice to know. It would have made the decision easier. It would have made us feel a lot better. So don't just think about this document from your perspective, but also from the perspective of the people who have to make this decision. So give everyone as much information as possible. In mine, I list about 10 things that I consider to be heroic measures at the end of your life. And then, also then I send a draft out to my clients and I say, please tell me if anything in here makes you uncomfortable, if you want anything added, taken out, and then I tailor it to exactly what they want. And you always have that right in this document. So don't ever let anyone tell you, well, legally you can't put that in there. Yes, you can. Yes, you can. As long as you tell them what you want about artificial nutrition and hydration, everything else can go into this document as well. Okay. And then finally, I want to mention, because I get this question a lot, is this a POLST? This is not a POLST. So a POLST is a physician's order on life-sustaining treatment. Okay. And this document also sometimes gets called a DNR. A POLST is the green piece of paper that your doctor will fill out and sign for you. And it is a doctor's orders. I cannot do this, nor can any other attorney do this for you unless that attorney is also a doctor. That is the only way that this document has effect. And a POLST is meant for a different situation than a healthcare directive. The healthcare directive is meant for when you are unconscious, in a vegetative state, in a coma, and you are at the very end of your life. A post is meant for any situation in which you're unconscious and unable to make healthcare decisions. So a post is the document that if you feel really strongly about not being resuscitated, for example, you go to your doctor, you fill out a post, they sign it, and that post says, "Do not resuscitate me." And then you post it up everywhere in your house. And that way, if an EMT comes into your kitchen and you've passed out on your kitchen floor and you're not breathing, they won't try to save your life. So that's the difference is, do they try to save your life or do they let your life end? Which is what a healthcare directive says, because you're already at the end of your life and they're just letting you pass peacefully, versus a post which says, no, don't try to save my life. If you come into my kitchen and I'm passed out on the floor, let it be. So that's the difference. Does that make sense to you guys? Yeah. Any questions about the healthcare directive at this time? Go ahead, Rosemary. You're muted, so I need.
Am I muted? Can
There
you
we
hear
go.
me?
There we go.
Okay.
Go ahead.
So two things. So then should we have both documents?
Yes.
Okay, thank you. And oh, one more thing. Where do you get it?
The post or the healthcare directive?
The post.
From your doctor. Any doctor can sign it.
So either one. I've got the green one, the other one, but okay. Thank you.
The healthcare directive you get from generally from an attorney along with your estate planning documents.
Okay, that's what I needed to know. Thank you.
You're welcome. Any other questions on these? No? Okay. So now I want to move to the stuff that has more to do with when you pass away. Okay. And we're going to start first talking about wills, and then I'm going to talk about trusts, and then I'm going to talk about how they work together and the complexities of the two of them. So a will is probably the document most people are more familiar with as far as estate planning goes. This is a document that says, this is my family, and this is my stuff, and this is where my stuff needs to go when I die. You also nominate a personal representative, and that personal representative is the same thing as an executor. You hear the term executor because in other states, many times personal representatives are called executors, but in Washington, it's a personal representative. Oops, sorry, my camera issue there. There we go. And that's the person who's going to be in charge of what your will says. So that person's only job is to take your will, take your stuff, read your will and see what it says to do with your stuff, and then make sure your stuff goes where it says. Then they're done with their job, okay? One of the things I was kind of alluding to earlier with Darlene's question is you could put all the contingencies in your will that you want, okay? Your will doesn't just have to say, when I die, take my stuff, give to these people. You can say, when I die, if my brother was nice to me and he said nice things about me at the funeral, then give him $10. And if he didn't, then don't give him anything. You can say if my kid is, oops, sorry, I don't know what's going on with my camera. There we go. You can say if my kid is on drugs when I die, don't give them anything. You can say if my kid really went ahead and married that woman I do not like, then don't give my kid anything. You can say if my kid finally divorced that woman I don't like, please give them everything. You can say whatever you want, and you can put whatever contingencies you want into your will. And this is why I say that it's possible to draft a will that will help you now while you have young kids, or later when you have older kids, or when you're retired, or when you need care, or when you're the second spouse in the marriage to die. You can create an estate plan that encompasses and thinks about and has contingencies for all those things, so you don't have to redo it later if things change. And the reason that I keep kind of hammering on that is when I do what I do with people who later need care, and I mention how important it is that your power of attorney is really thorough, and I'm going to mention again how important it is that we build these contingencies into your will. And the reason is probably 70% of my clients who need long-term care and who I'm doing crisis work for don't come in themselves. because they can't. Because they have dementia, or they're in a coma, or they're so sick that they can't make it in, or they can't understand the complexities of what I'm doing, or they're in the hospital currently. And in those cases, a lot of those people don't have the capacity, if they wanted to change their estate plan, to do it. And so you never know what's going to happen. And so if your estate plan is set up to already think about what would happen if something were to change later, then you don't have to worry about the fact that you could no longer change it if you lose capacity. Does that make sense to you guys as to why I keep hammering on this point? Okay. And then finally, back to wills. You can, and often in Washington, very much should, combine your will with a testamentary trust. A testamentary trust is a trust that is contained in your will. And I'm going to talk now about trusts and the differences in the different types of trusts. So there are two main types of trusts. There are living trusts and there are testamentary trusts. Living trusts, you probably have also heard about revocable living trusts, and that's a specific kind of living trust. Those are created while you're alive. They are documents and entities in which you say, okay, I'm going to create this will or this trust while I'm alive. I'm going to take my stuff and I'm going to put it in there now. And then when I die, this trust is going to control what happens with my property when I die. It also can control what happens with your property when you're alive. So it's a combination of the two. Sorry, I'm still having trouble with my webcam, keeps sliding. Sorry about that, you guys. Let's see if I can get it to stay. Okay. A testamentary trust is a trust that is created only after you die, usually by your will, and it continues from that point forward. So living trusts, you make them now and you put your stuff in them now. Testamentary trusts, you die and then they're in your will, and your estate is created by your personal representative of your estate, the person that I said is in charge of doing what your will says to do. Does that distinction make sense to you guys? Yeah, sort of. Not sure, at least? Okay.
Okay, I'm sorry, Liz, just name a couple items you would put in the living trust.
No problem. Let's use a house, for example, okay? So let's say that you are a single person. I'll just use a single person as an example here, though it works the same way with married folks, okay? Say that you're a single person and you want to make sure that when you pass away, your kids get your house, okay? And say you have 2 kids. If you do it the living trust route, then you create a trust now. And you are the person who creates the trust, also called a trustee or a grantor. And then you're also the person who is the trustee of that trust, which means you're in charge of everything that happens in that trust. And you're also the beneficiary of that trust. And that means that you get the benefit of everything that's in the trust. So if you create a living trust and you put your house in it, you essentially give the house to the trust. And then you manage the house and you do whatever you want with the house. You live in the house because you're the beneficiary of the trust. And you get to make all those decisions because you're the trustee of the trust. That's a living trust. And then it says, when I die, my kids become trustees and beneficiaries of this trust. So then you die, and your kids are trustees of the trust, and your kids are beneficiaries of the trust. So the house, in essence, belongs to them, but it passed by virtue of the trust. Okay?
Okay.
If you make instead a testamentary trust, and so then you're saying, okay, the house just belongs to me while I'm alive. It's my house. I live in it. I own it. I make decisions about it. It's mine. Stays the way it is, exactly probably the way most of you own your houses now. And then when I die, my will says, okay, when I die, personal representative, create a trust of which my kids are the beneficiaries. And maybe they're also the trustees, though usually not in that case. But this person is the trustee, and then my kids are the beneficiary of that trust. And the house goes into that trust after you die, and your kids then can either live there or you can sell it and they get the money from it. They're the beneficiaries of that trust, but it doesn't exist until you pass away. Does that make sense? Okay. All right. Anyone else have questions about the difference between those two? I know there's lots of questions about trust, but any questions about that in particular? No? Okay. So one thing I want to absolutely, unequivocally tell you and point out is that in the state of Washington, couples should almost never, ever, ever have a living trust plan. A revocable living trust for couples in Washington takes away our ability to do some of the best long-term care planning out there for couples. Okay? If you have a revocable living trust plan, unless you have out-of-state property that is in California or Nevada or New York or something, you know, a state like that that has really terrible probate laws, and unless that property is the only thing in the revocable living trust, then you should not have a revocable living trust if you're a couple in Washington. There are simpler and better ways to do planning for couples always in Washington with protections that we cannot do with living trusts. You guys have questions about that statement?
I do.
Go ahead, Angie.
So what if you have a big estate? What if you're kind of wealthy in the range of let's say $2-3 million? Does it make a difference for tax purposes to have a living trust?
Not a bit. So a living trust does not affect taxes for couples. So when you have a couple and you have a living trust, the state and everyone else considers that all of those assets belong to both of you. And so when you pass away, it's the same as if you had just owned everything. And tax planning for couples doesn't change whether the trusts that you create are testamentary or whether they're living trusts. So a couple that has $2 or $3 million, that's a really easy tax planning. And it's tax planning that should be done with a will. It should not be done with revocable living trusts. Anything you can do with a revocable living trust, you can do without it. So you might as well have the option to get the protections that are available with a will planning for couples instead of the revocable living trust. Does that answer your question? Kind of, anyway?
For now.
Okay, no problem. No problem. Now, what if you're not a couple? Because I'm saying this is an absolute total statement for couples. It's not an absolute total statement for single folks. However, most of the time, even for single folks, there are much simpler ways to do any kind of planning through a will in Washington rather than, and through testamentary trusts rather than through a revocable living trust. But if you are a single person, that kind of planning isn't fatal in the same way that it is for couples. So couples with revocable living trusts should have their planning redone. Singles who already have a revocable living trust, you don't necessarily have to undo it. There might be simpler and better ways to do it, but it's not fatal. It doesn't cause huge problems the way it does for couples. Does that make sense to you guys? Okay, all right. Revocable living trusts, when they are correctly funded, so I want to point this out. I actually had a client I met with just yesterday who she has a revocable living trust, she and her husband, and they had it because they had come up from Oregon and that planning made sense for them there. But they didn't have their house in the trust. And so not only was that trust, which was created in order to avoid probate, set up that way, but when they didn't put their house in the trust, they're going to have a probate anyway. So first of all, if your trust isn't correctly funded, even if it's set up to avoid probate, and even if you decide probate is absolutely terrible, which it's not, I'm going to talk about for a second, then if your trust isn't correctly funded, you're not even going to avoid probate. But that is the only thing revocable living trusts do right. They do not protect against anything else. They will not protect you against creditors. They will not protect you against the state. All the assets in that revocable living trust are countable for Medicaid purposes, so you're not getting around the Medicaid rules about how many assets you can have. Creditors can come in and put liens on assets in that revocable living trust. The state can put liens on that. It doesn't provide you any other protections at all. So the only thing it does well is avoid probate. In the state of Washington, probate is, first of all, not that bad. So I want to point out that we have a very simplified and useful probate process here in Washington. You probably hear horror stories of places like California that have probates where you have to pay extra taxes and you pay these huge attorney fees and you pay, and they take years and everything has to go through probate and they're awful and terrible and expensive. In Washington, not everything has to go through probate. It's a very short process. It's a pretty cheap process. There are no extra taxes or fees involved. Attorney fees are generally minimal, if any, and oftentimes it can be done without an attorney. And it can be really useful because it can help us get rid of some creditors. It can also help us set up these testamentary trusts for surviving spouses that give protections against all the things I just said revocable living trusts don't, including creditors, Medicaid, etc. And I'm going to talk about that kind of testamentary trust. So first of all, probate is not terrible here. Second of all, if your goal is to avoid probate anyway, and sometimes it is, if I have clients who don't need to set up a testamentary trust for some reason, then I don't set them up to go through probate. We avoid it if we can. But the fact is, in Washington, it's really easy to avoid probate without a trust of any kind. You don't need that kind of extensive planning in order to avoid probate here. So if that's your goal, you can do it so much more simply. And there's just almost never a good reason to get a revocable living trust in Washington. Other questions about that? Okay. Now I'm going to talk about actually useful trusts. Now that I told you these are completely not useful, I'm going to talk about what is. Okay. So testamentary trusts. These are trusts that are created by a will when you pass away. A testamentary trust can protect assets for a surviving spouse or a child or a loved one after your passing. It can protect those assets from creditors. It can protect them from the state. It can protect them from Medicaid, and it can protect them from unintentional disinheritance. Unintentional disinheritance is, I think I've actually got this on the next slide. Let me look here. Oh, nope. I'll get back to unintentional disinheritance. Long-term care costs are the biggest thing that threaten estates, especially later on in life, and especially for surviving spouses. Now, if you are a couple and one of you needs care. So in my example earlier, I think I said the husband needed care and the wife did not. So let's say you are a couple, husband develops dementia, needs to go into a facility, wife is still at home in the house, still living her life, still at home and needs to take care of herself and be able to pay her own expenses. If that husband needed care to be paid for, we could actually get him onto Medicaid no matter what their asset level is. So when we have a couple in the state of Washington, we can generally preserve all of their assets and get one of them onto Medicaid if they need long-term care. It's very easy. We have lots of processes by which we can do that. Couples have different rules from single folks in the state of Washington and actually all states for Medicaid purposes. And so we can get the ill spouse onto Medicaid without impoverishing the well spouse. However, if instead that husband needs care and the wife dies before or after he needs care, now the state treats him like a single person. So if the wife dies and leaves everything directly to the husband, then he's going to have to spend down all of his assets or do some other kind of planning before he can get onto Medicaid. So you got to go down to $2,000 before the state's going to help you pay for your care. You can also have a house and a car, but if the state pays for your care, when you die, they're going to get a lien on your house for all the money that they spent on your care, so they're eventually going to get it back anyway. Okay? So since long-term care costs can go from $2,500, which I don't think I so rarely even see something that low these days, up to $10,000, $14,000 per month, depending on what kind of care you need. You can run through even $1 million in not very much time, because at $10,000 a month, that's $120,000 a year, plus whatever other costs you've got just with where you're living. So you can run out of money pretty quickly with those long-term care costs if we don't do any kind of planning. One of the nice things about married couples planning is that if we put a testamentary trust into both of their wills, so this time husband needs care, wife dies first, and those assets go into a testamentary trust to benefit husband, that trust, that supplemental needs trust that's testamentary, has to be created in the will. It cannot be done with a living trust. Cannot. The state rules do not allow it. But if you do that, and instead those assets go into that trust, Medicaid can't count any assets in that trust. So that $2,000 is $2,000 plus everything in that trust. The state can't put a lien on anything in that trust. So if the house goes into the trust, for example, husband can get care, he can stay in the house, he can continue to receive care, Medicaid can pay for his care, and at the end of the day, when they're done, then the state doesn't get to lien on that house the way that they normally would, because they can't lien on anything in that trust at all. So then when husband eventually passes away, the house can go to the kids, like wife wanted it to before she died. Does that make sense? Yes. It's not touchable by creditors. And I keep bringing up creditors, and I want to point out that many times by the time we get to folks needing long-term care, they don't have creditors in the traditional sense. We're not talking about credit cards or loans or mortgages. I'm talking about creditors that, if you get in a car accident and you hurt somebody. So say wife dies and husband goes to her funeral. She's really distraught afterward, or he's really distraught afterwards, leaves the funeral, gets in his car, goes to drive home, gets in a car accident. He hurts somebody and they sue him for millions of dollars. Well, if you didn't do any planning and wife is dead already, husband owns all of their assets. So everything they own, including the house, now that person who got hurt in the car accident is going to come and take the assets of both of them and not just him. I mean, if he hurts her, he should pay out of his half of the assets for what he does. But also then everything wife left him is just going to be gone too. So that's what I mean by a creditor. I don't necessarily mean traditional creditors, although this also protects against them. They're generally not the creditors that we worry about in these scenarios. I had a client about 5 years ago, and we had done this kind of planning for them. It was an older couple, and I had done wills, and they had testamentary trusts in both of those wills. This couple had about $3 million, and he died, and she almost exactly this scenario, although she wasn't leaving the funeral. 1 month later, she got into a car accident, and she hurt some people, and then she died in that car accident. So we ended up where if we hadn't done that kind of planning, because he died first, that $3 million would have belonged to her. And then when she got in this car accident, all of that money would have gone to the people that she harmed in the car accident. Assuming, now that I don't think she did $3 million worth of damage to them, but assuming she did. Instead, because we'd done that kind of planning, certainly her half of the assets, her $1.5 million, went to these people whom she hurt in the car accident. But the husband, who was already gone, his half of the assets went to the kids the way that he wanted it to go. So that's an actual scenario that I'm not, this is something I've seen actually. And any other questions about this? I know I'm kind of going through a lot of stuff right now. Yeah, okay. All right. So the other thing, there are some other dangers I wanted to talk about. I talked about creditors. There's also scammers. And of course, you've all heard stories about people who mislead or trick vulnerable older adults into giving them money or assets. if instead of leaving all of those assets directly to the surviving spouse, we leave it into one of these trusts, you have a trustee who can kind of act as a middle person in between. So those assets aren't necessarily just open to that kind of trickery or those kind of scammers. And I want to point out at this point in time that these trusts can pay for anything the surviving spouse wants or needs. There's no restrictions on the things that these assets can be used for. But it does mean that that there's just this one layer in between that kind of gives a little bit of protection for, if you have somebody who is a surviving spouse and they're 90 years old and maybe they have a caretaker who comes in and doesn't so much take care of them as take them for a ride. And, then certainly that person can get access to the half of the assets that belong to that spouse, but the half that's in this trust is still there. So even if the scammer gets everything else, there's still money there to take care of that surviving spouse and then make sure that they can pay for the things that they need or want. Another one is unintentional disinheritance. I said I was going to explain this, and now I'm going to. Unintentional disinheritance happens when we have a couple who don't do any planning, so maybe a younger couple, or they do the traditional kind of I love you wills, which just say if I die, everything goes to my spouse and then to my kids equally. You guys have seen wills like that possibly. Just so you know, you don't need a will to do that in Washington. If you didn't have a will, that's exactly what would happen. So I love you wills really don't have any, they're not worth the paper they're printed on, essentially, because that's what would happen without a will. You really only need a will if you wanted to do something other than give everything to your spouse and then to your kids equally. So let's say this couple either did I love you wills or didn't do any planning at all. Okay. And say they have 2 kids. So say we have spouse 1 and spouse 2 and 2 kids. And the first spouse dies and spouse 2 gets everything. So now everything belongs to spouse 2 and they have the 2 kids. Much later on in life, spouse 2 gets remarried to a new spouse, spouse 3. Spouse 3 has their own kid, and spouse 2, who's much older than spouse 3, dies first. Didn't do any planning, so all of their assets go to this new spouse. Well, when the new spouse dies, that spouse's kid is going to get everything, and the 2 kids from the first 2 spouses get nothing. That's what we call unintentional disinheritance, because generally the older spouse doesn't mean to disinherit their own kids, but with lack of planning, that's what happens. So that's what unintentional disinheritance is. Does that make sense to you guys? Usually I can draw this out and I don't have anything to draw it on. So does that make sense? Okay.
And I had this happen. I've seen this happen live, and the disinherited child were adults at this point in time, and the children who actually did inherit said they were going to share the inheritance with the uninherited children, but they did not.
Yep.
I don't know why, but they just did not. So it does happen.
Mm-hmm. I see it happen, and it's not always malicious. Oftentimes it's not. It's just lack of planning. So how can a supplemental needs trust help? And I started to talk about this a little bit. As I mentioned, this trust exists for the purposes of supporting the surviving spouse or the kids. If you don't have a surviving spouse, this trust can be used for the kids as well. And you can make it contingent, which means that if the kids need it, you can use it, or if they don't need it, they can just get their inheritance directly. So again, everything in this trust is there for anything the surviving spouse wants or needs. If they need a new shirt, fine. If they need some food, fine. If they need or want a trip to Europe, fine. The trust can pay for all of those things. It doesn't violate the terms of the trust to pay for anything that they want. But nobody from the outside can come in and take any of it or force the trust to pay for anything. And that means that all of the assets in this trust do not have to be spent down in order to pay for things before Medicaid will come in. And so it can be used to pay for the things Medicaid won't pay for. And there are things that Medicaid doesn't pay for. Medicaid will pay for room and board in a facility and for care, either at home or in a facility, but they're not going to pay for motorized wheelchairs. They're not going to pay for hearing aids. They're not going to pay for dental work often. So there's all of these things that Medicaid doesn't pay for. And when you're on Medicaid, you only get to keep $70 a month of your own money. So you don't have that money otherwise to pay for it. So we use these trusts to kind of put aside some funds to supplement their care. And that's why we call it a supplemental needs trust. Again, nothing in there is lienable by the state. So even if Medicaid does pay for someone's care, then the state can't come and get anything when the beneficiary of that trust dies. Again, it's not touchable by creditors at all. And the terms of the trust control what happens when the second spouse dies. And that means that we don't have the unintentional disinheritance. So if husband dies and leaves his half of the assets into a trust for wife, then that trust is there to take care of wife as long as she's alive and pays for anything she wants or needs. And when she dies, the trust says, okay, now give everything to my kids. And that new spouse can't come in and change those terms so that you don't have that unintentional disinheritance. And the kids eventually get anything that's left over. So this solves kind of all of those problems I was just talking about. Does that make some sense to you guys? All right. So I tried to do this a little bit with diagrams, and it's not the best. Again, I prefer to write and draw this stuff out, but I'm going to do my best to kind of show how it works. Okay. So this first one is without a supplemental needs trust, after death, everything goes to your spouse. Okay. This means you've got yours and you've got your spouses, and you die and everything becomes your spouse's. And then any creditors of your spouse, the state, anyone else, everything is open to, your spouse has everything, and all of that stuff is open to those creditors, scammers, etc. With a supplemental needs trust, this time everything that belongs to you goes into the supplemental needs trust and is protected. So you have yours and your spouse's, and then when you die, you have the supplemental needs trust, which has everything in it that used to belong to you. And then your spouse still has their own stuff because your will only controls what you own, not what your spouse owns. And this time we have creditors and the state and unintentional disinheritance. Your spouse's half is open to all of that stuff, but the half that you left is completely protected from everybody and everything. And you can see my nice attempt at drawing arrows there. It's beautiful, I know. And if you ever want some better diagrams of this, I'm working on them. I'm doing my best, and I'm trying to develop them as we kind of move into this more virtual meeting space than we're used to. I'm a real big one for normally drawing on writing on whiteboards to show this stuff. So let me know if you want me to do some more detailed descriptions, and I can send you some stuff. Okay, so when should you plan? We're going to come back to this. So first and foremost, now. You should plan now. It's never too early to plan on this stuff. It's also never too late. Okay, so even if you're at the point where you are about to go into the hospital and you know you're going to come out, you're going to have to go into a facility and you need care, and you haven't done any planning up until then, it's never too late to do this stuff. Okay, your estate plan should be tailored to you and your family and your situation and your needs, and it should be flexible. It should allow you to go through the changes in life and still have it be effective and still provide these protections to you and your loved ones as well. And so even if you have nothing right now, at least go get powers of attorney, at least go start there. So it's never too early. When I do my estate planning stuff, I try to do it so that you will never have to change it again. And I'm most of the time successful on that. Unless somebody changes where they want their assets to go. So if you decide you want to no longer want to leave stuff to your son because he married that person you don't like, well, then you're going to have to redo your will in that case. But if your son becomes disabled and is going to need that trust to be used for his care, well, I've already built that into your estate plan. You don't have to change it later. I try my best to make sure that we kind of do it. And yeah, we want to review stuff. When I do this stuff, I always make sure that clients can call me and ask me questions at any point forward. And I also talk to Angie and other financial advisors about all this stuff together. But we shouldn't have to change it. So we might meet and we might talk about stuff and we might review it and what does it do, but not have to change it in almost every case. So again, it should cover contingencies because you never know what's going to happen. And if you have something, happen to you where you develop dementia or get in a car accident or some other reason, you can't change stuff later. Well, you're out of luck if you didn't plan for that particular contingency. So the more contingencies you can plan for, the better. And really, we do have the tools as attorneys to plan for so much of the things that can happen. And it's really not that difficult to do. Even for, if somebody's 21 years old and comes to me, I can develop for them an estate plan that will probably serve them until they're 90. It is possible to do. And also, your estate planning documents don't expire. I always like to bring this up because there are some people who do these kinds of presentations and webinars, and especially a couple of firms in Eastern Washington who like to sell revocable living trusts. We call them trust mills. I wouldn't call them estate planning attorneys. They're trust mill attorneys. One of the scare tactics they like to use is they will tell people that your powers of attorney are only good for 5 years. And so you have to have them redone. That is an out and out lie. Documents don't suddenly expire or lose their ability to be valid. Even when the law changes, which is rare in these areas, it's not rare in Medicaid, but it's very rare in estate planning stuff. Even when it changes, it doesn't undo the stuff that you already have. The power of attorney statute was changed in 2017. It was updated, it was clarified, it was there to make sure that everything that we'd had up to that point was understood by everybody. And it very specifically says, anything from earlier than 2017 is valid under the laws they were valid under before. But I've heard people say, oh, well, the law changed, so now I have to get new powers of attorney because mine are no good anymore. Or a bank might say, oh, it's older and it's no good anymore. That's not true. It's not true, and we have ways of forcing banks to honor those powers of attorney. But I just want you to understand, what you have does not expire. It doesn't go bad. So anyone who tells you that it does is just using fear tactics to try to get you to come in and buy their revocable living trust or whatever they're selling. Questions about any of this stuff?
No, but I'm going to remind you that it's almost 6:25. And
Okay.
so just FYI, if people need to jump off, would you mind just sharing your contact information if people need to jump off? But
Yep, I think I'll actually skip ahead and just see if there's anything else in here I need to cover, but I think I'm pretty much at the end. I don't really need to summarize I'll send out this PowerPoint also if anyone wants it. Just let us know if you want it, and I'll be happy to send it out as well as the other stuff that we're sending.
okay.
So hey, look, I only had one more slide anyway. So so who are we again? This is me. I'm Liz Wallace, and Agile Elder Law is my firm. I do estate planning, asset protection, VA planning, Medicaid planning, long-term care planning, crisis work, probate and estate administration. It's a long list of a bunch of stuff that really all is intertwined. This is my phone number, and this is my direct email, and that's our website. You can call or email me with questions about any of this stuff. I do a free consultation. And so if you want me to take a look at the estate planning documents you have, if you just want me to answer questions for you, if you want me to tell you what I suggest things you should have are, please do. I'm always happy to answer questions and give out information as well for those of you who work in long-term care. If you have questions for your patients or your clients as well, and that you just say, well, is there even anything they can do in this situation, and you want to shoot me an email and ask, please do. I never ever mind giving out information, and I don't charge for that stuff. I don't charge for consultations, and I don't charge to answer questions, and I actually would prefer you ask me, because then I can give you the right information rather than kind of guessing or wondering. So please feel free to contact me. And if you do want to have a consultation, I'm happy to do that as well. Again, bring your stuff in, let me look at all of it, tell you where you are, tell you what you might need. For those of you who are on the west side, I can do this via Zoom. For those of you who are on the east side, I could do this via Zoom if you want, or I can also, I have, you know, masks and gloves and social distancing standards set up as well for in-person stuff. I can also do phone stuff. Really, any way I can help you, that's what I want to do.
Can I just reiterate, did you say a free consultation?
I did say a free consultation, yes.
Okay, because that's really unusual in the attorney world. So.
Yeah, and it's unusual in the elder law world. This is one way in which I differ from my colleagues, in that a lot of them will say, well, I don't want to give a whole consultation, especially if it comes to long-term care planning, because then I'm giving away my expertise for free. I disagree with that assessment, honestly. If there's something that I get question I can answer where you don't need me to help you do the thing, then why should you pay me to do it? So I very much believe in as much honest and good information as possible. And then if you decide that you need me to do work for you, I'll tell you what it will cost then.
Excellent. Let's open it up for questions. Feel free to unmute yourself and fire away. And if you need to leave, that is A-okay as well. I'm still recording, so I think it takes a while for this to like download out of my computer and stuff, but I'll send it out. Would you like that? Would you like me to send out the recording? Okay, I'll just do that. We'll make a list of several things to send out, but please feel free to ask your questions.
I don't think I have questions. Oh, sorry. I don't think I have questions, but thank you, Liz. That was very informative. I will reach out to you.
You're very welcome. Thank you all for letting me be here and share information anytime.
There's so much to know. Sorry, Rosemary. Go ahead.
It's okay. So when you're in Eastern Washington, what do you have for an office? I mean, is it in Kennewick, Pasco, where?
I have an office in Kennewick, and I also have an office in Spokane.
Okay, thank you.
Any other questions?
So Lorna, were you asking, can a community property agreement help?
Okay, good question. So yes, it can, but it needs to be a part of your estate plan specifically. So you don't want to substitute everything I just talked about for a community property agreement, because a community property agreement just passes, unless you do it right, it just passes everything to the other spouse at the time of death. And that then would avoid all of the protections I'm talking about from the Supplemental Needs Trust. However, you do want to have a community property agreement that says everything we have is both of ours. Everything we get until we die is both of ours. But at death, we're going to pass it through our wills instead of directly to each other. So I actually do include what I call a property status agreement, so people don't get it confused with community property agreements. But it is actually a community property agreement. Does that answer your question?
Yes, thank you.
Okay, and let's see. So I want to go back up to Angie's question, Angie Stitzman's question. Did I answer that well enough for you?
Which one?
What about in instances where an older adult has a child as POA and seeks to transfer the home to offspring to remain Medicaid eligible?
That's
Yeah.
the other. Okay.
Yeah. Yeah, I got the clarification I needed. It sounds like it's not much different than Arizona. That was my concern. I didn't know how they varied state to state.
Okay, great. Let's see. And then Lynn has a question. How do you help the first spouse to get Medicaid assistance for long-term care when necessary? So I will keep this answer short and sweet, mostly because it can be a lengthier answer. But if only one spouse needs care, we have a few options depending on how many assets that person has. So the idea is basically that the state lets the spouse who needs Medicaid keep their $2,000. And then they also let the other spouse keep about $60,000 additionally of their own assets. Anything above that amount, we take and we put into what's called a single premium immediate annuity. So it's a Medicaid compliant annuity, and that annuity pays out to the spouse who doesn't need care monthly. So say you had $60,000 above what Medicaid allows you to keep. So say you had $122,000. $62,000 of that you just get to keep as cash in the bank or investments or whatever it might be. The other $60,000, Medicaid says, okay, well, we count, first of all, they count all the assets of both spouses together. Then you take that other $60,000 and we say, okay, well, we're going to put this into an annuity. That annuity is immediately going to start paying back to the spouse who doesn't need care, and it's going to pay over 5 years in equal installments. But if that spouse dies first, then the state gets what remains in the annuity towards whatever they paid for the other spouse's care, okay? So the spouse who doesn't need care starts to get money back immediately at $1,000 a month. And if they survive for 5 years, they've kept their entire $60,000 extra, and their spouse has gotten their care paid for the entire time, and the state doesn't get a lien on it. The state doesn't get any piece of any of their property whatsoever. And so then when the spouse who doesn't need care dies, it goes wherever their will says it would go. Okay. If they live for 4 years and 11 months, the state gets $1,000 because that's what's left in the annuity. So anything that pays back to the spouse is completely saved and protected. Does that make sense, Lynn? Okay. Does that make sense to everyone else? Kind of. Yeah. Well enough for our purposes today. Suffice it to say that annuities can help us protect all of those assets. There are some other things we might do in the case of spouses sometimes. That's the most common one. Okay. Let's see. All right, Tanya, as a single mother of 2 small children, how does their designated guardian fit into planning if something should happen to me? Should they be included in my planning process? Okay, so their designated guardian, first of all, you want to make sure that you not only designate a guardian in the will, because you do want to say, I have small children, and if I die, I want this person to be the one who takes care of them when I die. That goes in your will. It's a part of your planning. However, you also need it to go into your powers of attorney, because you might not die. That might not be the thing that happens that makes it so you can't take care of your children. So you also want to put that in your power of attorney. If I become incapacitated and I can't care for my children, these people are going to be their guardians and are going to make those decisions for them. Because otherwise, remember, your will doesn't take place until you die. So you want to make sure that that's also included in your powers of attorney for while you're alive. Should they be included in your planning process? Well, I certainly like to see that at least as part of what you want to have happen for your kids, because if they know what you want as far as care and decisions and that sort of stuff, yeah, I mean, that's the only way they know is if you tell them. So to that extent, they should be involved in your planning process, particularly if you're also going to leave money to them to take care of your kids, and you want to make sure that that money goes where you want it to go and that your kids get the kind of care that you want them to have. So I would like to see it. Does that mean it's required? No. It also doesn't mean that they have to show up at the meetings. You know, again, you can always leave additional information in a letter, or as I do in my values worksheet, that says, these are the things I want to have happen. So does that answer your question, Tanya? All right, great. Any other questions on this stuff? Oh, Angie, are you willing to share your values worksheet? You bet. No problem.
So in our poll, about 45% said that they were, they did have a plan for how their property will be transferred at death. So that really kind of mirrors the national statistics, I think. About half people do and half people don't. So that's a motivation to get something going. It sure seems like there has been a lot of people talking about estate planning and getting their wills done now with the coronavirus. Are you finding that, Liz?
I am. Yes and no. So I'm finding that older folks are absolutely getting stuff in place.
Yeah.
And I'm definitely finding that folks who are still working and are working in situations in which they think they might come into contact with the virus theirs. I've had doctors reach out to me recently to get their estate planning in place that they hadn't done. But I've also seen kind of a stagnation in the last month or so of people who have not been, as we kind of figure out what's going to happen next. And this is something that I don't think is a reflection of people particularly choosing not to make those decisions. I think it's a reflection of when we don't know exactly what's going to happen in society, we tend to freeze on all fronts.
Mm-hmm.
And so I have seen some of that in the last month or so. At first, I saw a lot more people saying, I want to get this stuff done. Now I'm seeing a lot more kind of, wait, let's see what's going to happen. I don't want to change anything because I don't know and I'm not sure what the future is going to hold, which is an understandable response. But what I would say is just at least have a conversation with someone like me, because then we can talk about what might need to happen and why it might matter and why it might not matter for the planning.
Right. And then the third question was, if I'm married, everything will automatically go to me. And we had 2 people say yes and 9 say no. So what's the answer? It doesn't, you talked about the sweetheart, Will.
Yeah. So the answer is, if you don't do planning, yes. With the exception of some kinds of property. I won't go into the real details of that. But yes, the answer is it will go to your spouse if you don't do planning.
Okay. And then estate planning is only a concern if I worry about taxes, and that's certainly not the case. I guess I can share these. Sorry.
No, that's okay. I was going to say the people who are worrying about tax consequences are the people who have couples who have at least $4.5 million. And there's certainly a whole lot of things to worry about when you have a lot less money, because if you have less money, you're the one who's going to run out and go broke if you need care. So I would definitely say taxes absolutely should be a part of the discussion, but they should never be the first concern.
Mm-hmm. Okay. Well, everyone, take advantage of her offer. It never hurts to consult, and she won't get her feelings hurt if something, she wants to be able to help people and get you pointed in the right direction. That's, I want to say a helping nature, it's part of her personality and just part of her being an elder law attorney, just a helper. You want to help people. So I encourage you to take advantage of that. So I want to say thank you, Liz, so much for, so much to know, honestly. Yeah, we can do a clap.
Thank you all. Thank you very much.
Yeah, thanks for taking the time tonight.
Thank you, Angie, for having me.
I'm glad it worked. This is kind of our first thing. So we're, I think it was a success. So if there's anything that comes up after tonight, ladies, feel free to reach out to Liz or myself, and we'll be in contact to share some of these materials with you in the next day or so, as soon as I can get things out. So, all right. Well, with that, have a great evening and enjoy the beautiful weather.
Thank you. Thank you all.
Bye. Bye. Hey, Lorna. I'm not going to end it until everybody jumps off. Oh, there they go. All right, I'm ending it. Ciao.